Under the Speaker's announced policy of January 6, 2015, the gentleman from Iowa, Mr. King, is recognized for 60 minutes as a designee of the Majority Leader.
Thank you, Mr. Speaker. Mr. Speaker, it's my privilege to be recognized by you to address you here on the floor of the United States House of Representatives. And I come to the floor here today with an issue that I think it's important that America have a dialogue on the topic, and some of that is going on. It's going on in the presidential races across the country and the coffee shops and at work, at play, at church, and around the country, and the things that we do. But when a moment in history comes along that shocked a lot of us to the core, and that was the abrupt and unexpected loss of Justice Antonin Scalia, a person whom I got to know. I'd like to say that I called him a friend, and a person whose personality I enjoyed a lot, his robust sense of humor, his acerbic wit, the way that he conveyed his messages, especially when he wrote the dissenting opinions for the Supreme Court. He found himself occasionally in the minority, but I think he was almost always right in those constitutional decisions. And when he wrote those minority opinions, he realized that, and he just thought in advance, that the students in law school would have to read the dissenting opinions as well as the majority opinions. And so he made sure when he wrote especially his dissenting opinions that they were engaging, they were entertaining, they were provocative, and they were challenging. And it caused the law school students to read those and remember the points that Justice Scalia had made. That's a legacy of the 30 years of Justice Scalia that will live within the annals and the history of the United States of America, especially those who are studying constitutional law and those that are in law school. The con law students around America too seldom are taught constitutional law out of the Constitution itself. And we have a President of the United States who spent 10 years as an adjunct professor teaching con law and at the University of Chicago. And I have met with a good number of the students that he taught. The ones that I met with, at least, said that whenever they laid out a conservative principle and made a constitutional argument based upon those conservative principles, that then adjunct Professor Barack Obama would always turn that around to the activist side to move the needle hard to the left. And it is my position, and I believe it is also the position of the chairman of the Judiciary Committee in the House, and especially the chairman of the Judiciary Committee in the Senate, that the Constitution must be read and interpreted to mean what it says. It mean precisely the text of the Constitution as it was understood to mean at the time of ratification. The Constitution itself, Mr. Speaker, is the equivalent of, and I'll say literally is, an intergenerational contractual guarantee from one generation of Americans to the next, to the next, to the next. Our founding fathers understood that, and they so carefully crafted this Constitution, and the language in it reflects their convictions and their guarantee to each generation. And if it were to be anything else, if it were to be a living and breathing document, as too many of our justices on the Supreme Court and far too many in our federal bench today, that 40% or so that will have been appointed by Barack Obama by the end of his term, those justices, by and large, don't believe what I've just said, Mr. Speaker. They generally believe that the text of the Constitution is something that they can massage, that they can manipulate, that they can interpret and reinterpret to mean that which they would want it to mean if it were written by them today. Of course, the words wouldn't be the same, but the ideology that grows from many of these precedent decisions shows that, is proof of it. And if anyone wonders, Mr. Speaker, I'll take them back to courts last June 24th and 25th. On one day, the Supreme Court concluded that they could rewrite law, and on the next day, the Supreme Court concluded that they could create not just new rights in the Constitution, but create a command in the Constitution. Now, I hope to return to that topic in a little bit, Mr. Speaker, but what we have in front of us is this. The loss of Justice Scalia leaves an empty seat in the Supreme Court, and it is an intellectual hole, not just a voting hole, but it's an intellectual hole left by the towering legal intellect of Justice Scalia. And in times throughout history, there's conflicting reports, but one can make the political argument, one can make the traditional argument as to whether a president should be able to make an appointment to the Supreme Court and have that appointment ratified and confirmed by the United States Senate. And under these circumstances that we have today, this is an election year, and the loss of Justice Scalia and the creation of that empty seat on the Supreme Court has brought about an appointment, a nomination, for the Supreme Court that has been produced by President Barack Obama, even though the majority party in the Senate, and concurring with the majority leader, Mitch McConnell from Kentucky, as well as the chairman of the Judiciary Committee, Senator Charles Grassley, have said, we're not going to take up a nominee, and we're not going to have hearings in the Senate Judiciary Committee, and that means that we won't have a debate and a vote on the floor of the Senate for confirmation, because they believe, and it's their prerogative to do so, they believe that the next justice on the Supreme Court should be a reflection of the voice of the people, who will go to the polls this coming November and elect a president of the United States who more accurately reflects the will of the people, rather than a president who is a lame duck president. And I agree with Senator Grassley, and I agree with Majority Leader Senator McConnell, that this is a decision that's too big to be made by people who are on the way out the door. The president is on the way out the door. There are members of the Senate that are on the way out the door. We need the fresh faces that have the freshest support of the American people making these decisions, particularly the next president of the United States. Now, predictably, when an argument like this comes up, each side seeks to gain a political advantage. And yes, this is a political decision. It's a political decision that needs to be based upon the foundation, however, of the Constitution and the text of the Constitution, the understanding of the Constitution to mean what it says and mean what it was interpreted to mean at the time that it was ratified. I mean, our founding fathers gave us a means to amend the Constitution, so they didn't intend for our Constitution to be a living, breathing document, as the people on the left say. They intended it to be fixed in place, an intergenerational contractual guarantee, so that my grandchildren and great-grandchildren and each succeeding generation can count on this Constitution meaning what it says. I've watched it distorted. I've watched it usurped by decisions made in our federal courts and by our Supreme Court, and a people and a public that will honor those decisions because they're made by the judges, not because they're constitutionally grounded decisions. And so this appointment that comes before the Supreme Court, first I will go to this. In our Constitution, Mr. Speaker, Article 2, Section 2, the authority of the executive branch of government must be here somewhere. Article 2, Section 2. This is the text we're working with, Mr. Speaker. This is the language that governs the appointment, the nomination, the nomination, the advice, the consent, and the appointment to the Supreme Court in this fashion. And I'll read this verbatim from Article 2, Section 2. He, meaning the President of the United States, this is executive branch authority, he shall have power, by and with the advice and consent of the Senate, to nominate, and by and with the advice and consent of the Senate shall appoint judges to the Supreme Court. Now, he shall have power to nominate, and by and with advice in the Senate appoint judges of the Supreme Court. Power to nominate and appoint by and with the consent, Mr. Speaker. And so, the language here is clear. By and with the advice and consent of the Senate. The advice and consent of the Senate is determined by the Senate. And the consent of the Senate is the confirmation vote. The advice would be, the President is to go to the Senate and say, I've got an appointment here to the Supreme Court. You all know that. You have some names you'd like to offer. What's your counsel here? Look at the makeup of the court. what is missing, what do we have, how are they contributing, what kind of job are they doing in ruling upon the supreme law of the land, the Constitution itself, and the text of the statutes that Congress has passed that go before the court for evaluation as to their constitutionality. And I'll go further than to suggest, Mr. Speaker, I will assert that we have a court today that too often reaches outside its bounds. And if I had a criticism of Justice Scalia, it would be his deeper respect for stare decisis than I happen to see, such as Clarence Thomas. But when a decision is made by the court, there's been essentially a consent of the court to accept that decision, to build on it, rather than to go back and reevaluate afresh, anew, from the text of the Constitution. I think we need to go back and refresh anew and take a look at the text of the Constitution with each decision of the Supreme Court with less deference to stare decisis. But the activists on the court, on the other hand, are the exact opposite. They want to build these leftward precedents along the way so that in the end the Constitution would be obliterated. That's the direction that President Obama has gone. It's the direction he seeks to go. And I would submit that I don't expect that he's going to be able to make an appointment to the Supreme Court that would reflect a justice on the bench whose interpretation of the Constitution would be to the text and the original understanding and meaning of it, but instead activist judges. That's the history that he's produced, and I've not evaluated the Justice Garland. I don't have a comment on his work, except that this is not the time to confirm an appointment for Barack Obama and let him shape this court for the next generation or so. If we get this wrong, Mr. Speaker, we lose our Constitution for the next generation. And no matter how astute our presidents have been, no matter how deeply they've been committed to the Constitution itself, we've still seen, even under Ronald Reagan, he got about half of his appointments to the court right. And we need a president coming around the pike that gets every one of them right. And I wouldn't be happy and satisfied until all 9 of the justices on the court reflected that they are traditionalists, that they're textualists, that they are originalists in the Constitution, and judges that are coming up in the federal bench would also meet that same standard. I'm not in the United States Senate. We don't have a vote on the confirmation of appointments to our federal courts over here in the House. I do serve on the Judiciary Committee, and this is into the 14th year that I have done that, Mr. Speaker. And so the voice of time and observation and reading and consideration and experience, especially as a member of the Constitution Subcommittee of the House Judiciary Committee, yes, I have deep convictions on this issue and considerable experience and knowledge base on it. And I'm suggesting, Mr. Speaker, that this House of Representatives evaluate the arguments that I'm making here and the arguments that Senator Grassley is making on the other side of the rotunda. And these arguments say, we take an oath. This will be my argument. Mr. Speaker, we all take an oath here to support and defend the Constitution of the United States. So do the judges of the Supreme Court take that oath to support and defend the Constitution of the United States. The President of the United States takes an oath to preserve, protect, and defend the Constitution of the United States. These are serious oaths. When you stand up before God and country and say, "So help me God," you better mean it. And that means that the Constitution isn't a malleable document. It's not. When you take an oath to support and defend it, that doesn't mean that you can take an oath to support and defend the Constitution as, let's say, amended by a Supreme Court. I would support and defend a Constitution amended constitutionally only. The Supreme Court justices are the last people on the planet that ought to be engaged in amending the Constitution of the United States. And so, but if I would take you back to those dates I mentioned, June 24th, June 25th, 2015. June 24th, if one would look at the calendar, it's going to be a Thursday. That was the date that the decision came out on Obamacare, and that was King versus Burwell. And that decision, Mr. Speaker, a majority opinion written by the Chief Justice, was this, that it boiled down to this. Congress passed a law in two different components. I call it Obamacare. They called it the Affordable Care Act. I've said that George Washington could not utter those words in referencing that legislation because it's not affordable. And George Washington could not tell a lie. But it was actually the Patient Protection and Affordable Care Act. And with that long lingo, threw people off, so they boiled it down to the Affordable Care Act. We boiled it down to Obamacare. Obamacare is far more descriptive than the Affordable Care Act and far more honest. But that legislation, it came in two packages. It was passed by hook, by crook, by legislative shenanigan. And that wasn't just me saying that. That was at least one Democrat here on the floor that used the term legislative shenanigan in reference to the passage of Obamacare. And it was passed in that fashion, and yet, when it began implemented, they wrote thousands of pages of regulations that could not have been imagined at the time that that bill passed the floor here. There was a massive amount of arm twisting and leverage like this country has never seen. We had tens of thousands of people that surrounded this Capitol and pleaded, keep your hands off of our health insurance, keep your hands off of our health care. They wanted their freedom. The people that came here understood this, that the most sovereign thing that we have is our own soul. And the federal government hasn't figured out how to tax it, how to nationalize it, how to take it away from us. We're in control of our eternal salvation. That's our soul, and we're managed of that. Each one of us manages it. But the second most sovereign thing we have is our health, our skin, and everything. And yet, this Congress, House and Senate, together with the President of the United States, on March 23, 2010, he signed into law the combination of the two bills that became Obamacare that I said were passed by hook, crook, and legislative shenanigan and have their own constitutional problems. I would argue the Supreme Court at least twice has ruled outside the Constitution in order to get Obamacare implemented. And one of those was the state exchanges. The statutory authority for the states to establish insurance exchanges under the auspices of the state exists within Obamacare. But the language that empowers the states to do so does not include the federal government. And the federal government did not have the constitutional authority to establish exchanges. And it needed the language. If the Obama administration had been astute, they may well have written into Obamacare legislation three words: or federal government, so that the states or federal government would have the legal authority to establish the exchanges. The federal government went ahead to establish exchanges within the multiple states that refused to do so, and the Supreme Court, its job is to read the text of the language and rule on the text of the language in the law. But yet, on a 5-4 decision of the Supreme Court written by the Chief Justice, they decided that if the Congress really might have, at that time, passed legislation with the language in it that would have said, or federal government, that they would just go ahead and interpret that it really means that, well, okay, it was an oversight on the part of Congress. They might have slipped that in there if they'd have just known that they needed to write it in there, but it was maybe an oversight by staff in the middle of the night, because after all, the then Speaker of the House, Nancy Pelosi, said, you have to pass this legislation in order to find out what's in it. Well, she didn't say we had to pass it to find out what in it, but what wasn't in it was the authority for the federal government to go into the states and intervene and establish their own exchanges within the states. But this Obama administration did that with the people's tax dollars, and I will say in violation of the law. And when it was appealed to the Supreme Court to assert just that, the Supreme Court ruled, well, it would have been better for the policy in their judgment if the language had been in there, or federal government. But it wasn't in there, so they deemed it in. That's a legislative decision made by a 5-4 decision of the Supreme Court that came down on us June 24, 2015. That is appalling to me. I'm aghast at the idea that a Supreme Court could be ruling upon the supreme law of the land and come down with a decision that they're now the legislative body to completely alter legislation that was the due decision of, I think, an erroneous decision, but a majority decision of the United States Congress. Now, in any other world, in any other time, in any other kind of a decision that would come down, a Supreme Court could, should, has, and would justly Send it back to Congress with this directive. We can't, and if you want this language in this bill, Article 1 says all legislative authority is vested in a Congress of the United States. So the only right choice for a Supreme Court faced with this kind of a decision was to not remand it back to a lower court for a decision, essentially, and I will say virtually, remand it to Congress and say to Congress, if you want to have federally established exchanges within the states, you have to pass a law that says so. That's not what they did. They decided that they could change the law over at the Supreme Court building. Now, if that can be done, if the Supreme Court of the United States can take on the trappings of a legislature and become a super legislature, and by the way, they're appointed for life, So there's no consequence for people who can't be voted out of office. You can't even replace them for the duration of their life. But they made the decision that they were the super legislature, and 5-4 under King versus Burwell, they put 3 words de facto, 3 words into the Obamacare legislation, or federal government. Now, I'm barely up off the floor from reading this on that Thursday, June 24th, 2015. And as the sun comes up on me on the following morning, I'm contemplating, what do we do about this? How does Congress react? What should the public messages be, for one part? And at 10 o'clock in the morning, here in D.C. time, at 9 o'clock in Iowa, 10 o'clock D.C. time, I'm rolling into St. Joseph's Catholic Church in Logan, Iowa, to do an event there with a visiting priest and with the parish there at St. Joseph's in Logan, Iowa, and who merged together at the same time. We pulled in and parked essentially simultaneously the vehicle of former Senator Rick Santorum, one of the leading constitutionalists in this country, one of the strongest people in defense of life and defense of marriage and defense of the Constitution that we have seen, and I'll say within a generation, with deep convictions, a clear understanding, and a very articulate voice. And as we got out of our vehicles, each of us had been listening to the news report of the decision that came down from the Supreme Court that day. And they can get their governor to sign the legislation or override a veto. Any one or any combination of or all of the states could pass the same-sex marriage law, and I would respect that as a decision, a constitutional decision made by we the people, whether it's we the people of Iowa or we the people of another state or all of the state for that matter, but not the Supreme Court, Mr. Speaker. The Supreme Court of the United States, they didn't just manufacture a right, they created a command to the states. And that is constitutionally offensive to me to read a decision like that. And by the way, I had a preview of it because the state Supreme Court in Iowa did just that in about 2009. And some of us dug down into that decision. That was about a 63 or 64-page decision. And it was an appalling, sloppy piece of legal work that was written with, I believe, a conclusion, and then they had to go through a lot of legalistic and mental and logical contortions to get to their conclusion. And I'd invite anybody to read that decision, and I believe that an objective reading of that decision brings them down with the same characterization that I would have. I want judges that read the Constitution and literally interpret the Constitution, and the judges that understand, as Justice Scalia did, that when he makes a decision based on the Constitution and the letter of the law, if he's uncomfortable with the policy decision that emerges with that, that tells him that he can be very comfortable with the constitutionality of the decision that he's made, because on policy he disagrees, but he knows that he's not there to determine policy. He's there, as Justice Roberts said in his confirmation, accurately, I think, to call the balls and the strikes, not to be the one that's a player in that arena. And so we have Chuck Grassley, the man who's standing in the gap, a man who is the chairman of the United States Senate Judiciary Committee, who has control of the agenda of that committee, and he decides whether there will be hearings before the Judiciary Committee on this appointment of the President or whether there will not be. And Chuck Grassley has said, in conjunction with Majority Leader McConnell, there will not be hearings in the Judiciary Committee. And Chuck Grassley is right, Mitch McConnell is right, and this argument gets cast back and forth throughout the, and it will be cast back and forth, and the amperage of this will go up and up and up between now and the election. They'll turn that into a political football. For me, I'd say take Chuck Grassley's word to the bank, and we're done talking about it. But they want the political leverage, and so they will be pressuring Chuck Grassley. Here's Mr. Speaker, a little bit of what's going on. And I'll say here is my public position on the issue, and it had to do with a press conference quote, where I said, and I quote, "There's no reason to have that hearing. The simple answer to it is this. It's inconceivable that President Obama would nominate someone to the Supreme Court who believes in the Constitution. If we're going to save our Constitution, we can't have an Obama nominee on the court." Period, close quote. Now, that's maybe a blunt statement, Mr. Speaker, but I've watched the history and the pattern of Barack Obama and the appointments that he's made to the court. There's no question that they are liberal leftist activists who want to come down with decisions that are more in the direction of the leadership of the ideology of the left than it has, and without very little deference to the founding fathers and anchored to the text of the Constitution. And then, I have given you what the Constitution says about nominations of advice and consent. But again, the President and by and with the advice and consent of the Senate shall appoint. In other words, the President can't make an appointment to the Supreme Court unless he has the advice and consent of the Senate. Now, advice could be fairly loosely interpreted, but consent is a different story. That takes the vote to do that. Judges to the Supreme Court. That means the President nominates, the Senate can provide the advice before the nomination. That would be the best, and perhaps some advice after, but the consent of the Senate's required, or there won't be a seat in the Supreme Court that's filled by Barack Obama. Now, I'd point out also, there's nothing in this Constitution that says that there has to be 9 justices on the Supreme Court. This is where the House could actually weigh in on this if we decide to do this. The Supreme Court, the Constitution of the United States requires that the Congress establish a Supreme Court. And then it's up to our discretion as to what other federal courts we might want to establish. And the Congress, we could, I had actually had this debate, Mr. Speaker, with Justice Scalia. One of the things I enjoyed about him was the little banters along the way on how these arguments came out. And I made the point to him that the Constitution only requires that the Congress establish a Supreme Court, not all the other federal courts. And so Congress could abolish all of the federal districts that are there. We could abolish it all. We could say there will be no federal courts. It'll all be handled through the Supreme Court itself. That's not a practical application, but it's from a constitutional perspective. And then I said to Justice Scalia that we could eliminate all the federal courts there except the Supreme Court, and the Supreme Court we could over time reduce. There's no requirement that the Supreme Court have 9 justices or 7 or 5 or 3. We could reduce the Supreme Court of the United States down to the federal courts. And so Congress could abolish all of the federal districts that are there. We could abolish it all. We could say there will be no federal courts. It'll all be handled through the Supreme Court itself. That's not a practical application, but it is from a constitutional perspective. And then I said to Justice Scalia that we could eliminate all the federal courts there except the Supreme Court, and the Supreme Court we could over time reduce. There's no requirement that the Supreme Court have 9 justices or 7 or 5 or 3. We could reduce the Supreme Court of the United States down to the justice. There's no requirement that we build or fund a building or heat it or wire it for electronics or anything. There's no requirement that we have staff for any of the Supreme Court. The Congress could crank all the federal courts down to just the Supreme Court, reduce the Supreme Court down to just the Chief Justice at his own card table with his own candle, no staff, and no facility. That's the argument I made to Justice Scalia. Now, some of this I do for entertainment value because he's always was a engaging fellow to have these conversations with, and I don't know if you'd ever heard this point made to him before, Mr. Speaker, but Justice Scalia's response to that was, he said, I would argue that there's a requirement that there be 3 justices on the Supreme Court. Otherwise, there's no reason to have a Chief Justice, which I thought was a pretty astute response, Mr. Speaker. But my response to that was, we've always had too many chiefs and not enough Indians. And so we had a little fun with that and moved on. But that's the leverage that the House has and the Senate has together. There's not a requirement that there be a 9th justice on the Supreme Court. I'm comfortable with that, and I'm supportive of that, but I want to fill that seat with someone that reflects the values of Justice Scalia, and perhaps one that will reflect even more closely the values of Justice Thomas in particular, and are a number of other justices that I admire on the Supreme Court. But another activist on the Supreme Court is not what this country needs. This country needs to have a constitutionalist, an originalist, a textualist on the Supreme Court that will reflect the meaning of this Constitution at its time of ratification. And that's why our founders gave us a means to amend the Constitution. They didn't intend for the Supreme Court to be taking on the trappings of a super legislature and legislating on one day by adding words to Obamacare, and the very next day create the new command in the Constitution that the states shall conduct same-sex marriages and honor same-sex marriages in other states. That's over the top. That's beyond the pale. If you can imagine what our founding fathers would say, how about the signers of the Declaration of Independence? If we could bring them to life today and walk them out here into Statuary Hall and say, take a look at this painting up here where you're all signing this Declaration of Independence. Or, better yet, go over to the archives where they pledge their lives, their fortunes, and their sacred honor, and you can still see John Hancock's signature there almost as clearly as the day that he may well have signed that. What would those founding fathers say if they knew that within a 24-hour window or maybe a 25-hour window, the Supreme Court of the United States has said, we're going to confer national health insurance on everybody in America, and Congress didn't write the law right, so we wrote it for them. And then the next day, same-sex marriage. You wouldn't find a single founding father that would agree with either one of those decisions, Mr. Speaker. And we're on the cusp of making an appointment to the Supreme Court that would feed this back to us and do more and more and more. How do you possibly teach the Constitution to young people? How do you teach civics to young people if the Constitution itself is moving in such a way that no one can predict what would happen? And so I see that I'm very pleased to see that I'm joined by another constitutionalist out of the state of Florida who is a clear thinker and has a good understanding, and that is my friend, the doctor and gentleman from Florida, Mr. Yoho, to whom which I'd be very happy to yield as much time as he may consume. The gentleman from Florida.
I'd like to thank my colleague for those kind words, and Mr. Speaker, good evening to you. I'd like to take just a quick moment to add to the important work that Mr. King is doing, and to thank my colleague for yielding me the time for his continued leadership in the fight to ensure the dignity of the Supreme Court so that it's not undermined by the nomination and subsequent appointment of a justice whose judicial ideologies run counter to the founders' constitutional principles, as you have spoken so eloquently about. The United States of America, the great experiment, an experiment that has surpassed centuries of speculation, persisted through the Civil War, an experiment that has survived 2 world wars and continues to stand as a beacon of hope to the nations across the globe, an experiment made possible because of the foresight of our founding fathers, and it had to have some divine intervention in because men aren't just that smart. So there was wisdom who recognized the necessity to establish a government ruled by a series of laws they felt were so essential to ensure equal opportunity, not equal outcome, equal opportunity in the pursuit of prosperity and happiness to all citizens. These documents, the United States Constitution and the Bill of Rights, I have them right here. And I want people to look at this. This is the entire Declaration of Independence and the Constitution. And I think if you look at it, we'll all agree it's not an epic in volume. Even my colleague across the aisle recognizes that. It's not an epic in volume, but yet it's an epic in ideology of what America stands for. And it stands for opportunity. And if you put work behind that, it becomes the American dream. Your American. The very fabric of this country is our core values, our founding principles, and the Constitution that preserves this. And that's the very document that gives people on the left a voice of dissension, as it does the people on the right a voice of dissension. And if we lose this, if we lose these principles, we lose that very argument, the very thing that made America great. And I ask you, are those ideologies, are they Republican or Democrat? Conservative, liberal, white, black, or any other adjective you want to throw in there? And I would venture to say that you would all say no. They're American ideologies. That's why this discussion is so important. The United States is facing an unprecedented attack by activist justices in both the lower and upper courts. If leaders were to yield to the demands of President Obama or any other executive in the future and nominate any individual who does not have a true, tried, and tested conservative record on constitutional issues, the ensuing Supreme Court opinions could be detrimental to constitutional law for years, if not decades to come. And I would surmise that if we cross that bridge and go beyond the constitutional principles of this country, what America is, what it has been in the past, and what we hope it to be in the future may be lost into the history of time. While I fully understand the importance of having a full bench, all 9 justices, available to hear some of the most critical cases of our time, it should not be done at the expense of our Constitution. That's a document we all should revere. We all should stand up and protect. After all, don't we all give an oath to uphold that sacred document? As American culture has ebbed and flowed, and it will continue to, morphing to what it is today, it was these founding documents that fostered an environment where the voice of the few, not just the many, could be heard. And that's the beauty of our country, a constitutional republic. So many people want to refer to it as a democracy. A democracy is majority rule. A democracy is mob rule. And as Ben Franklin was often quoted, a democracy is the same as 2 wolves and a sheep deciding what to have for lunch. As we know in that story, the sheep always loses. So that's why it's so important, because a constitutional republic protects the rights of the minority, of all people. And American culture, as I said, has ebbed and flowed over the period of time, and it's morphing and it'll continue to morph. They have allowed for the people to dictate change, not a man who likes to remind the American people that he believes he can rewrite our history, and through the use of his phone and a pen, direct executive agencies to act with disregard to the voice of the people. A pen and a phone are not a replacement for the legislative body. And it's the Senate's chore to pick that person. Take, for example, a vital case about to be argued before the Supreme Court next week, United States versus Texas. To some, this may seem as a pro-immigration case. But at its core, it's not about whether or not you are anti or pro-immigration. It's about whether or not the Supreme Court will allow the executive branch to circumvent Congress and legislate from the Oval Office rather than through Capitol Hill the way it was intended by our founders. I believe the Constitution is clear on this issue, but I also believe any justice who does not have a deep appreciation for the Constitution, as the late Justice Scalia did, would disagree with me. Therein lies the danger. Any justice who is willing to tip the scales in the balance of power in favor of a runaway presidential office, just this administration, it could be any in the future, and that's why this is so important. This crosses party lines. A political ideology that I would argue threatens the very fabric of the foundation and the founding of our nation. Congress cannot allow itself to cave and settle for a justice that would be complacent in the destruction of the Constitution and ultimately the destruction of the great American experience. I challenge the President to get serious with this nomination, put forth the name of a justice that will uphold the constitutional principles and not legislate from the bench. In the meantime, I urge my colleagues in the Senate to hold steadfast and not allow themselves to be persuaded by public opinion, public pressure, and by those who will try to pressure them to vote for any nominee who will do the American legacy and the American people an injustice by undermining the Constitution from the highest court in this great nation. This discussion is so important. At the very fabric of this discussion and the very basic of this discussion is about the preservation of this institution. That's what this is about. This institution has, if you look at a timeline of human history and you look at the American experiment, it is but a dot on that period of time. But it's created the greatest country in the world. And the reason that has been allowed is because of the Constitution. And again, those ideologies aren't Republican. They're not Democrat. They're American ideologies that we will all benefit, and we all have a hand to preserve those. We can have our differences, but this is one thing we shouldn't differ on, and this is for the posterity of all Americans, conservatives, liberals, white, black, anybody else. And this is something we stand strong, and I appreciate the gentleman from Iowa, my colleague, Mr. King, for bringing this up. And I thank you for continuing the fight and bringing this out to the American people. This is important, and thank you.
Reclaiming my time and thanking very much the gentleman from Florida for the compliments, but the input here too. And I learned something in this discussion and listening to Mr. Yoho from Florida, and that is when he spoke of divine intervention in our Constitution, that the answer, it required divine intervention because men just aren't that smart. I hadn't heard that expression in this town or any place before. It explains it in a lot of ways, and I've long said that I believe that the Declaration and the Constitution are written with divine guidance. And I choose those terms because the Bible was written with divine intervention and divine inspiration. That's up here. Divine guidance is just a little click below that. I don't want to claim biblical standards, but it's really close. And we would not have this country if it were not for God's guidance of our founding fathers. And so I tune my ear to that. And I'd say also that whose advice should the senators listen to on the other side? Well, they should listen to Ted Yoho's advice. I hope they're listening to my advice, Mr. Speaker. But those on the Republican side of the aisle are pretty solid. And I want to publicly and personally thank my friend whom I appreciate and respect a lot, Jerry Moran, who's been in a difficult place in Kansas. He is a terrific friend, and I serve with him here in the House of Representatives, and his position is shored up in opposition to having hearings in the Judiciary Committee and trying to move this, and I think the reconsideration that he has done is a good thing, and I hope the people of Kansas understand and appreciate Jerry Moran in the fashion that I do as well. And I would suggest that maybe Jerry Moran and some Democrat senators in particular may have been listening to this advice, Mr. Speaker. This would be advice from the Vice President himself, Joe Biden. Advice that he gave on June 24th, 1992. So it has sustained the test of time in this fashion. It's called the Biden Rule. Quote from Vice President Joe Biden, quote, "It is my view that if a Supreme Court justice resigns tomorrow or within the next several weeks, or resigns at the end of the summer, President Bush should consider following the practice of a majority of his predecessors and not, repeats it, and not name a nominee until after the November election is completed." That's Joe Biden, and at that time he was the chairman of the Senate Judiciary Committee, Mr. Speaker. And again, that was June 24th, 1992. We're only a couple of months away in proportion to that in this period of time. Well, so if our friends over on the Senate side are not listening to the Vice President, I'd suggest they might listen to the Senate Minority Leader, Harry Reid, the former Majority Leader in the Senate. This is Harry Reid's statement made in 2005. And you'd note that this was back when George W. Bush was president. Harry Reid, Minority Leader today in the Senate, quote, "The duties of the United States Senate are set forth in the Constitution of the United States. Nowhere in that document does it say that the Senate has a duty to give presidential nominees a vote. It says appointments shall be made with the advice and consent of the Senate. That's very different than saying every nominee receives a vote. The Senate is not a rubber stamp for the executive branch." Close quote. That's Harry Reid, 2005. Both of those gentlemen, I would say today, would argue against their previous. I'm reinforcing their arguments today on the floor of the House of Representatives. And we're not finished, Mr. Speaker. Who's another strong, influential voice over there in the Senate Judiciary Committee? Senator Schumer of New York. He wanted to block the Bush nominees. And here's what he had to say. He said, quote, "We should not confirm any Bush nominee to the Supreme Court except in extraordinary circumstances." He cited that's close quote. He cited Senator Schumer cited ideological reasons for the delay. And I begin another quote. "They must prove by actions, not words, that they are in the mainstream rather than we have to prove that they are not." Close quote. Well, there's a statement of ambiguity for you, Mr. Speaker. Requiring an appointment to the Supreme Court to prove that they are in the mainstream. What's the mainstream? That would be what Chuck Schumer would define as the mainstream, depending upon whether or not he supported the candidate that was seeking to present themselves to be in the mainstream. I would argue that mainstream is not a requirement for an appointment to the Supreme Court. The requirements for the appointment to the Supreme Court are determined by the discretion and the judgment of the confirming senators over on the other side of this Capitol building, and they should be obligated to only confirm justices who interpret the Constitution to mean what it says. To mean what it says. Is that too much to ask? Why then do we have a Constitution if it can't mean what it says? Senator Schumer wasn't done, however. He argued again in 2007, quote, "We should reverse the presumption of confirmation. The Supreme Court is dangerously out of balance. We cannot afford to see Justice Stevens replaced by another Roberts or a Justice Ginsburg by another Alito." Close quote. That was 2007. I think the Supreme Court is dangerously out of balance precisely because of the justices that Senator Schumer supports and because there are not enough justices on the Supreme Court that he has opposed. Because I believe that the justices need to reflect and protect the text and the original understanding of the Constitution, and every founding father believes that as well when they went to their grave, and they would be rolling over in it if they saw a Supreme Court that was writing law on one day, manufacturing commands the next day, and now hearing an argument that the President of the United States has a right to his appointment to the Supreme Court, no matter what kind of activist he might serve up, that is going to visit upon the American people for at least the next generation decisions that usurp the authority of the United States House of Representatives and the United States Senate and commandeer the legislative authority away from Article I and commandeer some kind of authority to manufacture commands as they did last June. Then, we're not done yet. In case this argument isn't strong enough at this point, Mr. Speaker, here's another. That would be then Senator Barack Obama, now President Obama. He filibustered the Alito appointment, the Alito nomination, excuse me. And here's what then Senator Obama argued in 2006. Well, they say this of him now. This is his spokesman today. Quote, "President Obama regrets filibustering the nomination of Supreme Court Justice Samuel Alito in 2006. This is from his top spokesman, who said just a week or so ago, though he maintains that the Republican opposition to his effort is to replace Justice Scalia is unprecedented. No, the President of the United States' opposition to Justice Alito was unprecedented, not the opposition created here by Chairman Grassley or Majority Leader McConnell and almost every Republican over there in the United States Senate And I don't know any Republicans in the House that think they ought to move this appointment now. So here's some other positions along the way, Mr. Speaker, regarding Senator Grassley's comments. And that would be, that Senator Grassley made some strong positions on the floor of the Senate a little over a week ago. And they were published in Politico, as I recall, where it would be this, that the Supreme Court has weighed in on this nomination. And that would be Chief Justice Roberts has intervened and made comments in this way, that before Scalia had passed away, he argued that the confirmation process is not functioning very well, that it's gotten too political. And I was very proud of Senator Grassley when he stepped up on the floor of the Senate and rebutted that argument, and he made the case that no, the confirmation process in the United States Senate has gotten political precisely because the court itself is making political decisions rather than decisions based upon the law and the supreme law of the land, the Constitution. And so when you see political decisions come out of the court, and those decisions, I've described some of them, there are many others, that means that the confirmation process itself is political. And when I sit before the Supreme Court and hear the oral arguments before the court, and I hope to do that again next week, I was amazed. I expected that I would hear profound constitutional arguments before the United States Supreme Court. I mean, I grew up, I guess, naively believing that were the arguments made before that court. And I think the Warren Court had already turned that thing in the other direction, and I didn't realize it. But when I first sat before the United States Supreme Court and listened for those arguments, thinking it was going to be an amazing educational experience for me, what I found was there weren't any profound arguments made. Those arguments instead were being made to the swing justice on the court to try to get to that individual's heart because they understood the various proclivities or in the thinking and the rationale that might come. They understood. They went back and looked at the lives, the lifestyle, the history of the judges and wondered what moves their heart rather than what moves their rationale. We should only have justices whose rationale is moved by constitutional arguments before the court. And we have let's see, who else do I have? President Obama that made the argument that he wants appointments to the Supreme Court that have, what is the word? Compassion, empathy. President Obama's word is empathy. We're not looking for empathy on the Supreme Court. We're looking for justices that can rule on the letter and the text and the original meaning and understanding of the Constitution and the letter and text of the law here in Congress that we pass. And yes, they can take into consideration congressional intent, but they can't amend the language. If the language says one thing, they don't get to add words to it, and they should ship it back over here and tell us what they've interpreted that it said, and then the Congress can decide whether or not we want to act. And we take an oath to support and defend the Constitution. That doesn't mean we're bound by a decision of the Supreme Court that turns the Constitution on its head. And so this fight that's going on in the Supreme Court with the nomination to the court now is one that will turn the destiny of the United States of America. Depending on who ends up as the next president of the United States, I have every confidence that Senator Grassley holds his ground and that there will not be hearings before the United States Senate Judiciary Committee, and that the Senate prerogative will prevail, and that the people will go to the polls in November and elect a president, and part of that decision will be that will that president make the right appointment to the Supreme Court. And in the meantime, Chuck Grassley, the man who is now the chairman of the committee, stands in the gap in the same way that Leonidas stood against Xerxes at the Battle of Thermopylae. When he led the 300 to stand in that gap and face 300,000 Persians, he's holding his ground. He's holding his ground nobly. He's holding it with conviction. He's holding it with determination. And we need to stand with him, beside him, and behind him in every way that we can, and understand that this is a political assault that's going at him, and we should reward him for his convictions by electing a president who will make that appointment to the Supreme Court that reflects the will of the people. And the will of the people, I trust, will still want to see an appointment to the Supreme Court of a justice that would stand up and say, this Constitution means what it says. The text of this Constitution has to mean what it says, and it has to be interpreted to mean that which it was understood to mean at the time of its ratification. And if you don't like what it does for our policy, then get to work and amend the Constitution. That's why that provision is there. That's why we have the amendments to the Constitution today. So I thank Senator Grassley for his strong stand. I thank Mitch McConnell for his leadership in the Senate. I thank everyone over there who holds their ground, and everyone here in this Congress that takes an oath to support and defend the Constitution and means it. And with that, Mr. Speaker, I would yield back the balance of my time.